When cross-examining a witness at trial in a civil case, why am I allowed to ask leading questions? You want to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. So now, whether it's a medical malpractice case or an accident case or a wrongful death case, when I go ahead and stand up to cross-examine a witness, I am permitted to ask leading questions. And here's the key reason why. I don't want to ask the witness who is adversarial to us, who is opposing us, to go ahead and explain anything to the jury. That's not the focus. I want to ask specific questions. You want to know why? Because I want to tell the story through my pointed, specific questions. I either want the witness to answer yes or no, to agree or disagree. That's very, very important. And that's totally different than if I put a witness on the stand. Now I want to have them explain something. Mr. Jones, explain to the jury what happened here. Tell us your events of what you observed. How did this happen? And those are open-ended questions that I will always ask my client to go ahead and explain to the jury. However, let's say in a medical malpractice case where we're suing a doctor for improper medical care, I never, ever want to give that witness the opportunity to explain. His attorney will go ahead and have that opportunity when I'm done questioning the doctor. And now, when I get up to question the doctor, I want to tell the jury in my words our version of the events. And here's an example of questioning a doctor during cross-examination. Doctor, isn't it true that when a patient presents with X, Y, and Z, you're now going to perform a differential diagnosis to evaluate the patient's condition, correct? Yes. And part of evaluating that is you formulate what's known as a differential diagnosis. Isn't that true? Yes. And that means you're creating a list, either in your mind or on paper, about the most likely causes for this patient's problems. Isn't that true? Yes. And in this particular instance, the patient had X, Y, and Z, correct? And you would agree that good medical practice requires that you think of this condition as the most likely cause first. True? And now what am I doing? I'm setting up a story for the jury to understand in step-by-step sequence. I'm not giving the doctor the opportunity to go ahead and explain to the jury what his rationale was, what his thinking was. I know from pretrial testimony exactly what the doctor did and why. But now I have to tell the jury our version of the events, our story. I have to lay a foundation to show the jury that the doctor violated the basic standards of care. And the only way I can do that is by asking leading questions in this type of scenario. So why do I share with you this great information? I share it with you to give you an insight and an understanding to what goes on during trial on cross-examination. You know, I realize you're watching this because you likely have questions or concerns about your own particular matter. Well, if you're deciding whether to bring a lawsuit for your medical malpractice case, your accident case, or even your wrongful death case, and you have legal questions, what I encourage you to do to get more information, pick up the phone and call me. This is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.